Thank you very much, Mr. President. Excellencies, ladies and gentlemen, as South Sudan continues its nation-building efforts, we must recognize the mountain of challenges the country still faces. From the inter- and intra-communal violence that continues to claim many lives and undermine the stability of the country, to a protracted humanitarian crisis of food insecurity, as well as massive floodings. Not to mention the spillover of the Sudan conflict into South Sudan, resulting in the movement of more than 750,000 refugees and returnees. Add to this a seemingly deteriorating economy exacerbated by the disruption of critical oil infrastructure and revenues. Hence, at the start of this update, I would like to emphasize the urgency of immediate international action and support for South Sudan to address the many challenges it faces. OHCHR notes the extension of South Sudan's transitional period for 2 years, with elections rescheduled from December 2024 to December 2026. I call on the government to demonstrate political will to implement the outstanding aspects of the roadmap to the peace agreement in order to ensure a successful, peaceful and democratic transition in 2026. And I call on the international community to continue supporting South Sudan in this endeavor. OHCHR, through the Human Rights Division of the United Nations Mission in South Sudan, has provided technical assistance and capacity building pursuant to Human Rights Council Resolution 55/26. In March 2024, the UNMISS Human Rights Division provided technical assistance to the South Sudan Human Rights Commission and representatives of civil society organizations to conduct 2 field visits in Malakal, Upper Nile State, and Kuachokka, Warrap State. The support aimed to facilitate the Commission's work in monitoring, investigating, and reporting on human rights violations and abuses. Weak rule of law and accountability mechanisms for human rights violations and abuses and violations of international humanitarian law continue to contribute to pervasive impunity and lack of effective remedies for victims. Judges and staff of judicial entities in South Sudan face logistical constraints, restricted access to detention facilities, and complicated security conditions. This affects their performance in the dispensation of justice. As a result, customary courts continue to oversee the vast majority of judicial proceedings, including in matters that fall outside their competence. This situation contributes to the prevalence of impunity and lack of accountability for perpetrators. Nonetheless, customary courts play an essential role in dispensing justice at the local level, where statutory courts do not exist. The high patronage enjoyed by the customary courts is because they're easily accessible, affordable, their proceedings are easy to understand, and the decisions reached by the courts are acceptable to the people. Despite these advantages, the exercise of jurisdiction in criminal matters by customary courts has substantial human rights implications on fair trial, particularly in severe criminal cases such as murder and rape. In addition, many inmates found in prisons are products of cases heard by customary courts not competent in areas of formal justice, contributing to overcrowded prisons with poor detention conditions. For those cases overseen by formal courts, the lack of consistent access to legal representations for detainees continues to result in lengthy pre-trial detention. Moreover, the absence of nationwide policies and mechanisms to protect victims and witnesses further hinders victims' access to justice and reparation. To help address some of these challenges, the UNMISS Human Rights Division continued to provide technical support to mobile courts deployed in conflict-affected areas where no statutory courts exist. Between January and August of this year, mobile courts were deployed to Koch, Mayom, and Bentiu in Unity State to address the backlog of criminal cases and handle appeals from customary courts. Since then, the governor and citizens of Unity States have cited the Bentiu mobile courts as bringing peace, justice, and security to the citizens, and that it shows that those who commit criminal offenses will be held accountable. In fact, citizens have expressed keen interest in the justice system. They traveled from the counties of Bentiu during the rainy season to file cases and continued to crowd the mobile court until its last day. They have called for the mobile court to become permanent. In fact, the government has requested the judiciary to deploy permanent judges and UNMISS to support a second mobile court in Bentiu in November of this year until the permanent deployment can be realized. In collaboration with the UNMISS Rule of Law and Security Institutions Section, relevant government ministries and civil society organizations, the UNMISS Human Rights Division conducted awareness-raising campaigns and witness and victim protection before and during the deployment of the mobile courts. It monitored the proceedings and court processes for compliance with due process, including in cases of rape and murder. Technical advice was also provided to relevant state and non-state actors on victim and witness protection. The UNMISS Human Rights Division organized at least 80 capacity-building activities and provided technical support to authorities, armed actors, formal and informal justice actors at the national and local level. These different forms of technical cooperation aim to strengthen their capacity in human rights accountability and the fight against impunity. Furthermore, the UNMISS Human Rights Division continued to provide technical assistance to state-level justice actors to address the case backlogs in the criminal justice system. This support included joint review of case files, as well as guidance and training on human rights standards regarding arrest, detention, investigation, and use of force in law enforcement. With the support of the UNMISS Human Rights Division and other agencies, the government has taken important steps to advance the transitional justice process. An important development has been the third reading in the Parliament of the bills on the Commission for Truth, Reconciliation, Healing and the Compensation and Reparation Authority. Both bills have been passed to the fourth and final stage of reading and will be presented to the President to sign them into law, and the transitional justice mechanism will be established when the laws are enacted. In this context, the UNMISS Human Rights Division, in collaboration with the Transitional Justice Working Group, engaged several stakeholders during the first and second quarters of 2024 to update and deliberate on the status of the two bills. Among them were members of the reconstituted Transitional National Legislative Assembly and the consolidated views and opinions of all interlocutors consulted were presented to the Specialized Committee of Peace and Reconciliation. It is crucial that the government of South Sudan intensifies efforts to implement all the transitional justice mechanism in Chapter 5 of the revitalized agreement. This includes signing the Memorandum of Understanding with the African Union on the establishment of the hybrid court for South Sudan. Restrictions on fundamental freedoms remain prevalent in South Sudan, affecting individuals and organizations perceived to be critical to the government. This has negatively impacted civic and political space and the creation of an environment that is conducive for free, inclusive, and credible elections. On July 3rd of 2024, the reconstituted Transitional National Legislative Assembly amended the National Security Service Act 2014. This has generated concerns about civic and political space and personal freedoms, particularly regarding the retention of sections 55 and 54, which permit the national security powers to arrest under emergency circumstances and for broadly defined crimes against the state, which remain controversial and susceptible to abuse. The UNMISS Human Rights Division has expressed concerns to the government about this law. Civil society actors have actively advocated for the President to reject the bill as it is incompatible with South Sudan's obligations under regional and international human rights law, and OHCHR encourages the President to consider the concerns to avoid a potential increase in cases of arbitrary arrests and detentions, especially of government critics. To contribute towards an open civic and political environment, the UNMISS Human Rights Division conducted a series of trainings and advocacy for over 12,000 persons, including almost 4,000 women. These trainings focused on fundamental freedoms and human rights, the role of civil society organizations in the electoral process, the protection of civic space, political participation, and transitional justice. And as a result of these training, a Human Rights Defenders Network for Unity State was established in March 2024. Excellencies, to close, allow me to point out again that Sudan stands at a critical juncture. It needs all the support it can get. Acknowledging its many challenges, OHCHR is fully committed to maintain its active engagement and to continue its cooperation with South Sudan to address these challenges. Thank you for your attention.